Welcome to Core Bar Studies, Criminal Law Sessions, Session 3. This is Professor Jack Guttenberg. This session will focus on conspiracy and attempt. We will begin with conspiracy and conclude with attempt, and in the conclusion we will review solicitation, accomplice liability, conspiracy, and attempt. Let's begin with conspiracy. The elements of conspiracy at common law are an agreement between two or more persons to accomplish a criminal or unlawful purpose or a lawful purpose by unlawful means, with the intent to enter into the agreement and the intent to achieve the objective of the agreement. In a number of jurisdictions, an overt act is required, and by overt act it can be any act in furtherance of the conspiracy: going to get the map of the bank, going to get a getaway car, hiring another conspirator. Anything that furthers the conspiracy will most likely be considered an overt act if the jurisdiction requires an overt act. Now let's look at the agreement, a meeting of the minds between two or more people. Does not have to be explicit. It can be a nod, a wink, a yes. So the guy with the sunglasses says, thinks I intend to agree, I intend to complete the crime. Will you work with me to kill my professor? Sure, I intend to agree, I intend to complete the crime. I agree to do that. At this point we have a completed conspiracy. We have a meeting of the minds between two or more people. Between two or more persons has certain limitations. Each person to the agreement must have the intent to agree and the intent to commit the target offense. We won't have a conspiracy if they are one of them is feigning agreement, that is, they don't really intend to agree or they don't intend to commit the target offense. They're an undercover police officer. They're not capable of agreeing. They're a protected class, that is, in statutory rape, the person is under the age of consent, or the crime takes two to commit. But if there is a third person involved, then you will have a conspiracy. So another example, each person to the agreement must have the intent to agree and the intent to commit the target offense. So our sunglasses here thinks I intend to agree, I intend to complete the offense. Will you work with me to kill my professor? Our baseball hat guy says, I agree to do that, but I am a police officer, he's thinking. I intend to agree, but I do not intend to complete the crime. At this point, there is no common law conspiracy because we do not have an agreement between two or more people who both intend to agree and intend to commit the target offense. The Model Penal Code handles this distinctly different. It uses what is known as the unilateral approach, and it states the defendant agreed with another to commit the crime. The defendant is guilty of conspiracy even if the other is feigning, an undercover police officer not capable of agreeing, or part of a protected class. Under the Model Penal Code approach, only one of the parties has to have the purpose to agree and the purpose to commit the crime. So let's go back to our two hapless folks here. Mr. Sunglasses thinks I intend to agree, I intend to complete the crime, and says, will you work with me to kill my professor? Mr. Hat says, I agree to do that, but I'm a police officer, he's thinking. I intend to agree, but I do not intend to complete the crime. Under the Model Penal Code, this is a completed conspiracy, and Mr. Sunglasses can be charged with conspiracy. This is different than the common law approach. Under the common law approach, there would be no conspiracy, but under the Model Penal Code unilateral approach, there is a conspiracy. Let's take a look at some special issues with conspiracy. The first one to talk about is the Wharton Rule. That basically states that if the crime needs two to complete, there is no conspiracy unless there are more than two involved in the conspiracy. So, if there is a third person, then you can have a conspiracy. Some examples: adultery, it takes two to commit the crime of adultery. Dueling, it takes two to commit the crime of dueling. Two people could not agree to have a duel and be charged with conspiracy to duel. Two people could not agree to commit adultery and be charged with the crime of conspiracy. Conspiracy does not merge with the target offense. You can be convicted of conspiracy and the target crime, except in certain jurisdictions. Ohio is one of them. Ohio merges conspiracy into the target offense. So in Ohio, if the defendant agrees with another to commit murder, the defendant can be charged with murder and conspiracy, but cannot be convicted of both of them. The conspiracy will merge. This is not the case at common law. At common law, the defendant, as will be seen later, can be charged with conspiracy and with the completed crime of murder. Next, conspirators are liable for crimes committed in the furtherance of the conspiracy. That is, all crimes that they commit furthering the conspiracy, and as long as those crimes are the natural and probable consequence of the conspiracy. That is, they are foreseeable. An example: conspiracy to commit bank robbery. Stealing a getaway car and shooting a teller during the commission of the bank robbery most likely will be found to be the natural and probable consequences of the conspiracy. However, if during the bank robbery one of the robbers rapes one of the tellers, this most likely would not be seen as a crime committed in furtherance of the conspiracy. That is, it would not be seen as the natural and probable consequence of the conspiracy. At common law, there was no withdrawal from conspiracy. Once all the elements of conspiracy are met, the crime is completed, and all of the conspirators could not withdraw and use that as a defense to the crime of conspiracy. However, they could withdraw and limit their liability for further actions of the conspirators. However, they must perform an affirmative act that notifies all members of the conspiracy, and notice is given at a time that they can abandon their plans. You'll see this later when I go through solicitation through attempt. However, the Model Penal Code permits withdrawal from a conspiracy. It permits withdrawal or abandonment as an affirmative defense that can be raised by a withdrawing conspirator to the charge of conspiracy. Conspirator must renounce their criminal purpose and take action to thwart the success of the conspiracy under circumstances demonstrating a complete and voluntary renunciation of her criminal intent. So let's look at attempt now. The elements of attempt at common law are intent to engage in conduct that constitutes the actus reus of an attempt, intent to commit the target crime of the attempt, and must engage in conduct that goes beyond mere preparation and is proximate to the completion of the target offense. The question really becomes, how close has the defendant come to completing the offense? And the answer usually is the defendant must be dangerously close. If you remember back to first year criminal law, there were a variety of solutions to this actus reus problem. So, our example here: Mr. Baseball Hat has his gun. He's approaching room 545, thinks to himself, I intentionally got this gun to shoot the professor, and I have come to his office to do so. He also thinks I intend to kill the professor. I know he's in there. So the question remains, did he come proximately close to committing the offense? That is a question that the prosecution and the jury will have to answer. Under the Model Penal Code, let's look at attempt. Acting with the culpability required for the commission of the target offense, that is, whatever culpability is required for the target offense, the defendant must have. Purposely engages in conduct that would constitute the crime if the attendant circumstances were as he believes them to be, that is, his conscious object to engage in conduct that would be the crime if the facts were as he believed them to be. So he does everything he can do, and under the facts as he believes them, would that be a crime? Purposely causes, or with the belief that it will cause, such result without further conduct on his part. And finally, purposely does or admits to do an act under circumstances as he believes them to be, that is a substantial step in a course of conduct planned to culminate in the offense. We will take a look at each of these. Must be the conscious object to engage in conduct. That is conduct when you do everything you can do and there is nothing more to do. You must purposely engage in that conduct. Purpose or with belief that the conduct will cause the result. This is for a result crime, like murder. Purposely believes that their conduct will cause murder. We'll see this in a few minutes. And finally, purposely engages in a substantial step. Now, what is the substantial step? The actus reus for Model Penal Code attempt is a substantial step, in most instances for an incomplete attempt. This broadens liability beyond proximately close for common law. Substantial step must be strongly corroborative of the criminal purpose. That's the question that gets asked. Was the defendant's conduct strongly corroborative of their criminal purpose? Let's go back to our Mr. Baseball Hat with his gun approaching room 545. He's thinking to himself, it is my purpose to kill the professor. I know he is in there. I purposely got the gun, purposely came to his office to shoot him. So now, under the Model Penal Code, the question is this a substantial step? Is it strongly corroborative of the criminal purpose? Standing outside the professor's office with a gun. Let's look at some other special issues for attempt. Abandonment or withdrawal from the attempt. At common law, there was no abandonment. Once the defendant has gone far enough to constitute an attempt, the crime was completed and one could not abandon. This was a completed offense and there would be no defense of abandonment at common law. Under the Model Penal Code, withdrawal is permitted and can be used as an affirmative defense, but only if it is full and voluntary, cannot be because the crime is more difficult or an increased risk of getting caught. The defendant who leaves the scene of the crime hearing sirens approaching will not be said to have affirmatively abandoned their attempt. It will be because there is an increased risk of getting caught because the police are coming. And the abandonment must be complete under circumstances manifesting a complete renunciation. You cannot just be postponing or for a time when it would be more convenient to do so. It must be a complete renunciation of the criminal purpose. Now we're going to look at several issues around impossibility. This is impossibility is raised with attempts for various factual and legal reasons. So let's take a look at factual impossibility. That is facts that as they are make it impossible to commit the crime. This, in almost all jurisdictions today, is not a defense. Goods are not stolen, so the defendant is charged with attempting to receive stolen property, takes the book in hand that he believes has been stolen, but in fact the book has been recovered or it never was stolen. This will not be a defense to attempt stealing. There's nothing in the pocket to pick. The defendant puts his hand into the victim's pocket intending to take the wallet that the defendant believes is there, but there is nothing there. Again, this will not be a defense. Shooting it into an empty bed. The defendant believes that the victim is in the bed, intending to kill them, fires 3 times into the bed and leaves. But unbeknownst to the defendant, the victim was never there. This will not be a defense because the facts as the defendant believed them to be would be a crime, pulling the trigger of an unloaded gun. If the defendant believes the gun is loaded, this will be sufficient for an attempted murder or an attempted assault. That is, if the facts as the defendant believed them to be would make the conduct criminal, then impossibility is not a defense. That's the question to always ask when impossibility can be an issue. If the facts were as the defendant believed them to be, would it be a criminal offense? And if it is yes, then it is not a defense. Let's take a look at legal impossibility. This is totally different. When the defendant's goal or conduct is not against the law, even if the defendant thinks that it is. Filing income taxes on the 16th, thinking that they are due on the 15th and intending to file them late on the 16th, when the 16th is the actual due date, will not be a violation of the law. Same with having sex, consensual sex with a 16-year-old when the defendant thinks that the age of consent is 18. That is, the defendant thinks the person is 16-year-old, the defendant thinks they're violating the law, but the law makes the age of consent 14. In each of these instances, there is no crime to be committed despite defendant's belief that it is a crime. In these instances, legal impossibility will be a defense. Merger. One cannot be convicted of both attempt and a completed offense. One can be charged with both. A defendant can be charged with both attempted murder and murder, attempted robbery and robbery, but can only be convicted of one or the other. So, now let's take a look at all of these issues that we have been talking about. Solicitation, conspiracy, accomplice liability, and attempt. So, Mr. Sunglasses thinks to himself, I intend to hire you, I intend that you commit the crime. I want to hire you to kill my professor. He has the intent to hire, the intent to encourage, the intent to engage, and the intent that the person kill the professor. This is a completed solicitation. At this point, we have the crime of solicitation. Before Mr. Baseball Hat has said anything, there is the crime of solicitation. I intend to agree. I intend to kill the professor, thinks Mr. Baseball Hat, and says, I'll do it. At this point, we have a conspiracy. There has been a meeting of the mind at common law between 2 or more persons with the intent to agree and the intent to complete the target offense. The solicitation now merges into the conspiracy, and both will be charged with conspiracy, and Mr. Sunglasses will not be charged and convicted for solicitation. So now Mr. Baseball Hat goes to room 545 with a gun and thinks it's my purpose to kill the professor. I purposely got the gun, purposely came to his office to shoot him. So now the question becomes, is this a substantial step or is he proximately close that would make this an attempt? That's the remaining question that has to be talked about. And therefore, it most likely is an attempt, standing outside the office with a gun, intending to shoot the professor. So now we have Mr. Sunglasses, I want to hire you to shoot my professor. I will do it. Later he says, I shot into the professor's office thinking that he was there, but he wasn't. Now we have Mr. Baseball Hat as the principal to attempted murder. Mr. Sunglasses, through accomplice liability, is also guilty of attempted murder. Mr. Baseball Hat is a principal to conspiracy. Mr. Sunglasses is a principal to conspiracy. The solicitation by Mr. Sunglasses merges, and the conspiracy of both of them does not merge, and both of them can be convicted of attempted murder and conspiracy in this instance. Let's go on. I want to hire you to shoot my professor. I will do it. Later, I shot into the professor's office and killed him. Now, Mr. Baseball Hat is a principal to attempted murder or murder, and most likely murder since he killed him, but he could be charged with attempted murder as well, because maybe the professor died from other causes. The accomplice, who was the one who solicited, gave him the gun, encouraged him to do it, with the intent to encourage and the intent to commit the crime of murder, is now an accomplice to attempted murder or murder. And Mr. Baseball Hat is a principal to conspiracy, and Mr. Sunglasses is a principal to conspiracy. Mr. Sunglasses, who originally solicited, that solicitation merges. The conspiracy that they're both guilty of does not merge, and they both can be convicted of either attempted murder or murder and conspiracy. That is, the conspiracy in most instances does not merge. Now, as I said earlier, in Ohio, the conspiracy would merge. That is a special rule that pertains to Ohio and not common law conspiracy. In Ohio, these two could only be convicted of attempted murder or conspiracy, but not all three of them. That concludes this session of Core Bar Studies.